Welcome to Ask an Atheist. I'm Rebecca Markert, the legal director here at the Freedom from Religion Foundation.
And I'm Liz Cavell, Associate Counsel for the Freedom from Religion Foundation.
From Minnesota, and I'm Senior Counsel at FFRF.
Today we are going to be talking about the banner week civil rights had at the Supreme Court last week. As you're likely aware, just in the last week, the court handed down decisions in 3 of the 4 cases we here at FFRF were watching. We're going to discuss those religious liberty cases and what it means for the separation of church and state.
And as always, if you have questions for today, please feel free to submit them right on the Facebook page comments, or you can email them to askanatheist@ffrf.org. 2 of those cases the Supreme Court issued last week had enormous repercussions for state-church separation. Those cases were Carson versus Macon and Kennedy versus Bremerton School District. So today, we 3 are going to break down those decisions and discuss what it all means for the Establishment Clause. So we're going to jump in first with the Carson versus Macon decision, but just first, let's get a little background on the case. What is this case about? How did it get to SCOTUS?
Sure. So I'm going to back up just a little bit because I also want to acknowledge that another decision came down, the Dobbs versus Jackson Women's Health decision, and we are not going to discuss that today. We're going to have a show on that devoted completely to that next week.
That's right.
So tune in to hear about the abortion case next week. And I also want to just take a minute at the outset to really acknowledge the legal team here at the Freedom from Religion Foundation. Patrick and Liz have been integral in putting together amicus briefs before the U.S. Supreme Court. The Supreme Court has taken the most religious liberty cases that we've had in our career here at FFRF, and to be able to handle all of the shots that came last week, the beating that we received, and still get up and come to work this week. It's been a hard week to be a civil rights attorney.
Yes, it has.
And I really just wanted to acknowledge how well they've represented FFRF. And our membership, I'm sure, really appreciates you guys fighting the good fight. So thank you very much. So Carson v. Macon, the first upsetting decision that we received last week. The background to this case is this is a case that comes out of the state of Maine. In Maine, they do not have enough secondary schools, public secondary schools, so to service all the kids that need to go and complete their K-12 education. So the state of Maine has a tuition assistance program by which the parents can designate which school they would like their child to attend, and the state will funnel taxpayer money to those schools. Of course, there was a requirement that those schools be non-sectarian. So of course, we have 2 sets of parents who are religious, and they want to send their kids to private religious schools. These 2 sets of parents then sue over this law in Maine, and it finds its way up to the Supreme Court, where really the question is, can the state of Maine fund religious education?
Right. Or can the state of Maine not fund religious education, because the status quo being what has been agreed upon for decades to be required by the Establishment Clause, which is that government funding does not go to fund religious education. So Maine is doing right by its constitutional obligations by funding its public schools and public school alternatives. This is not a voucher program or, a scholarship assistance program. This is Maine making sure that students that live in rural school districts that don't have enough students to operate a secondary school have some other alternative to get the public education that they're entitled to. Some districts choose to do that by allowing the school or the student or the student's family to designate which school they want to go to, and the state will pay that school for that pupil's attendance. It's supposed to take the place of or be in the place of the public school education that every student in Maine is entitled to. So this is direct funding to religious schools.
And these particular schools are also problematic. They are really far right type of religious schools. So they do not allow, Bangor Christian, I believe, is the first school. They do not allow their students to be of LGBTQ. They cannot, exhibit any sort of non-conforming gender behavior at all. They will expel those students who identify as LGBTQ. They do not want to hire those teachers, and they also ask that the students themselves really subscribe to this born-again Christian religion.
Right.
And in addition to that, they require the students to refute the teachings of Islam. And Temple Academy, which is the other school at issue in this case, is very, very similar, where they want their students and their faculty, including the janitor, to really glorify Jesus Christ.
Right.
So it's not just that they're sending them to this religious institution, it's the religious institutions that are also discriminating.
Right, right. The most conservative Christian schools, possible are the ones that are represented in the facts of this case. So what does the court do?
Let's ask Patrick and bring him into the conversation.
What did the court do?
Bringing me in to do the fun part. Yeah. Yeah, no. Well, I mean, not surprising. So we knew once they took this case, this was a bad sign. We've gone from, the question of whether a state is permitted to do this type of thing under the Establishment Clause to the question here is, must the state of Maine fund religious education? And so by not really a surprise, you have 6 conservative justices to the 3 liberal justices rule that, it violates the Free Exercise Clause to exclude religious schools from this program. And you have a opinion written by Chief Justice John Roberts saying that. And why it's kind of surprising, and I say, for this court that, and maybe we'll get into this a little later, that really seems to be stuck on, the tradition and history and the way that the First Amendment must be interpreted. This is a pretty shocking revelation because 20 years ago, so in 2002, the Supreme Court had to answer the question of whether, Cleveland had a voucher program, whether that was constitutionally permissible under the Establishment Clause. To now the mandatory nature of it, if there's a program that funds private religious education, you must fund religious education. And so it's quite surprising. I don't know why the court 20 years ago couldn't have discerned this, because clearly that's how we're supposed to interpret the First Amendment, is looking at, there's clear answers apparently according to these justices. So it's really a concern that, going from it, and even a few years ago, there was the idea that you couldn't exclude a religious entity from a program just because it's affiliated with a church, but maybe you could if it was going to use that money for religious activities. And so here, I think as the facts that, Rebecca, that you brought up, and Liz, there's no doubt that these schools are doing religious activity. They're fundamentalists, and they are teaching religion, as they say, in all subjects. So it's not just there's a religion class that happens to be offered. It's taught in their science curriculum. So now you have the Supreme Court saying that Maine can't, make a decision to exclude them. And what Maine was really trying to get at was about half of their school districts don't have secondary schools, half. And so they were trying to put something in place of that. What would be in place of what would provide a secular education to all students? And now you have the Supreme Court telling them they can't exclude these schools because they're teaching religious matters. There does seem to be some opening as to, well, maybe not all religious schools are going to participate in this program because they might not like the terms. And so I think it was either today or just yesterday, the Attorney General of Maine had pointed out, they have a Human Rights Act that prohibits discrimination. And so they've amended that to make sure that schools receiving public funding have to abide by that act. So in terms of student admissions at these schools and even employment, there may be some religious schools that aren't going to take the money because they're afraid of, violating their religious principles. They want to discriminate against LGBTQ students or on the basis of religion, and they may not be able to do that under Maine's rules. So I guess that's a little bit of the where we may be right now today, but the court's opinion is really concerning. And I don't know if either of you have more to share on that.
I think also what's really concerning is the speed at which this is happening. Like Patrick mentioned, it's only been 20 years that they said this may be permissible, you may be able to do this, to now where you must do this. And then this status versus use distinction that Patrick brought up, where you couldn't exclude them from funding because of who they are, being a religious organization, but you could exclude them if they're going to use the funds for religious activities, like Patrick was mentioning. That status use distinction was really only 5 years old. It came down first in the Trinity Lutheran case from 2017, and then was brought up again in Espinoza. And we here on the show have been saying, well, at least we still have this. But within the span of 5 years, they obliterated that distinction as well. And Justice Roberts is the one who wrote all three of those opinions. And so I really don't understand why he suddenly just changed his mind about that. But it really turned the law as we know it on its head.
Right. Yeah, the status use distinction that Patrick mentioned was at least a line that it kept intact the principle that public funds, and this is part of the Establishment Clause, there's supposed to be two clauses there, in the First Amendment, the Establishment Clause and the Free Exercise Clause. And we'll get into what the dissent had to say in a minute, but this completely elevates all the free exercise concerns of the religious actors to completely eclipse any concerns with balancing the Establishment Clause side on the part of the government. And the status use distinction just completely went out the window, where the majority here says, you know what, like, it doesn't even matter. It's discriminatory to even withhold funds from a religious organization because there's no difference between status and use. If they want to use the money for religion and you don't want to give it to them, you're discriminating because of their religion. And so that just completely went out the window in the span of a few years.
Right.
So 3 justices were in dissent. Of course, this was along party lines. The ultra-conservative majority is now 6-3. So let's talk about what the dissenters had to say.
Yeah, our favorite Justice Sonia Sotomayor. She's the one who's always writing amazing opinions, amazing dissents these days. But here's a quote from the dissent. She wrote, "This court continues to dismantle the wall of separation between church and state that the framers fought to build. Today, the court leads us to a place where separation of church and state becomes a constitutional violation."
Right. That's exactly what I was just trying to point out, which is the whole object or the whole project of governments that are trying to maintain separation of church and state, this court views as a violation of the free exercise rights of religious organizations that want government money and that want government support.
Right. The anti-establishment interest that the government might have is not a compelling interest that would override the free exercise interests of the individual. And that is concerning, because then you are in a situation now where taxpayers are being forced to fund religious education for other people and that type of religious activities that they might not agree with and that they may not want to fund discrimination either.
Right. Patrick, can you talk about how this is a change? The dissent was really focused on what used to be the way the court analyzed the 2 clauses of the First Amendment and how that has just lurched completely into this radical space.
Yeah, I don't know the exact wording. I think, and Sotomayor, who's my favorite justice, basically said, I warned about this, because she did write a dissent in the 2017 decision that Rebecca mentioned. And then I don't know if she wrote or joined a dissent in the 2020 decision about Montana's voucher scheme. But there was kind of this idea that there was this play in the joints between, free exercise clause allowing free exercise of religion and the establishment. And now it's kind of a one-way street. And we see that theme in the second case we'll talk about. But really, it's become the dominant force is, funding and allowing for religious activity is now taken over, really taken over the Establishment Clause. And I think Justice Sotomayor is right on when she's kind of highlighting some of those concerns.
Yeah, and one of the things I kind of wanted to mention that's a little bit of a side issue to the merits here, but Patrick kind of touched on it earlier in his discussion of the background, which is the schools in this case, or the way that this Supreme Court majority cherry picks its litigants that it wants to privilege, right? It picks out these religious litigants, plaintiffs, and like come hell or high water will decide these issues in a way that privileges them, even when the controversy that remains before them might not actually like be ripe for the picking. And so like what I mean here is these schools, Pat alluded to this, I can't remember if one or both of them don't currently take money from this program because, as Patrick said, they don't necessarily want to be bound by the other terms of the strings attached to the money, which is that this is public funding going to provide public education to students in these districts. So they have to abide by the state academic standards and some types of non-discriminatory non-discrimination requirements related to disabled student enrollment and accommodations and things like that. And these schools are so ultra-conservative, they don't readily agree to any of those things. And so they weren't even actually seeking to participate or take money from the government in this program, but yet, and that might be considered in other cases a reason why the court would refrain from deciding this case, because the actual schools in question, it's somewhat of a hypothetical question. But of course, that doesn't stop this court from ruling on these issues. And we don't even hear mention of standing or any of these other hurdles to getting the court to decide these cases. And that I find also very frustrating. It's like we're breezing past any issues with standing or the ripeness of the controversy or the appropriateness of these particular litigants. Like, this court doesn't care. It is ready to reach out, grab these cases, and issue an opinion that preferences the ultra-conservative religious litigants.
And along those same lines, the schools haven't indicated that they would take the money because of the regulations that you mentioned, but also the parents, one set of parents is already sending their children to these schools without that money from the state. They have been attending the school. Another set of parents sent one of their children to the school but couldn't afford to send the other. And of course, in this situation, they sent the boy, not the girl, to get this better education. So, I mean, that also, the question of how injured are they comes up.
Right. Not that it was mentioned at all in the case or that there's any focus on it, but it's become something that's really frustrating given how many hurdles we as litigants have faced just getting the courts to reach the merits of our cases. But yet this court is so eager to take these cases that touch on these religious liberty issues, which I put in air quotes because, the only religious liberty interest that matters is that of the ultra-conservative litigant. It doesn't matter the liberty interests of, the taxpayers of Maine or the state of Maine that is trying to protect this other religious liberty interest, which is non-establishment by its own state government.
Well, the other thing is, I think I also probably misled everyone too. Sonia Sotomayor did write a dissent, but I believe that the main dissent was from Justice Breyer in this case.
Yes, they each wrote separately to dissent in this one.
Yep. And we at FFRF are pleased to see how he is going out. He is retiring at the end of this term, and he really has, in these really the last two religious liberty cases has really also given a really good dissent and really trying to uphold state-church separation.
Right. So
really trying to get his legacy in there. I don't know if you have anything more to say about that, Patrick.
No, and he's not, he's pretty neutral in his view of state-church separation. So he's not like he's always been on our side in every case. I think he's kind of taken those cases and felt, what's really good for state-church separation, what's good for democracy. And in his dissent in Carson, he kind of talks about, not wanting discord. And that's kind of what we're forcing on people if we're going to be funding, contentious schools contending over religious education. So I think Breyer does leave a very good legacy. We haven't always agreed with him on some cases, but I think he's left a very strong dissent in this case and the joint dissent in Dobbs, the abortion case that all three liberals joined.
Right. Well, so we have time to fully discuss the other case, and as if this case wasn't enough for us to process in the religion clause realm, the court also handed down its decision last week in Kennedy versus Bremerton School District. And this was a case that kind of had a pretty long backstory and comes out of the state of Washington, and it also has to do with public schools, but it has to do with the religious practice of teachers and coaches. So, Patrick, can you give some background on Kennedy?
Yeah, and I'm going to give the warning that not everybody agrees on the facts because
well, everyone agrees except for those living in the alternate universe.
Right. There's a reality of what happened in this case, and then there is reading the majority opinion of the Supreme Court. But Joseph Kennedy was an assistant football coach at the Bremerton High School in Washington. He had engaged in prayer activities with students, both in the locker room and then also on the 50-yard line immediately after games. And that included, I think that practice took about 7 years. He was doing that with students. They invited the opposing teams even. It became a big thing, and he would do motivational speeches. When the school district found out about this in 2015, they started to have conversations with him to try to stop it because they were worried about coercive pressure and, the district being liable for a school staff member paid pushing religion on students and on players on the team. So then he gets lawyers involved, and they start to have letters back and forth discussing, well, how can we accommodate him? Because he says, it's my religion. He's a Christian. My religion requires me to pray on the 50-yard line after games. So there's some discussion of the school district. They say, hey, you can use the press box. You could go inside the school. There's all these places you can do it, but we think it's a problem if you're going to, say these audible prayers on the 50-yard line. He doesn't agree to any of that. So they put him on administrative leave. By the way, at this time, he was going on Fox News and national media saying, hey, everyone, join me on the 50-yard line for prayer. So it was really a group activity. And in reality, I say that because the Supreme Court majority doesn't necessarily view it that way. So he's put on administrative leave throughout that end of that season. And then the way that the football contracts work is he didn't apply to come back the next year. But the school district was certainly concerned that he was going to be pushing religion on players. He sues and asserts both a free exercise of religion right and a free speech right, saying, hey, I'm doing my private speech and activity at this point. You guys are censoring me. The Ninth Circuit and the district court rule against him and rule that the school district was in its rights to rule this way. And they do that because of the Establishment Clause. The school district was correctly worried that it would be, pushing religion on kids if it was going to allow a coach to do this. So that's the setup to the case, in coming to the Supreme Court, and they've changed it a bit, in terms of the facts. So, if you read the opinion, which was, I think it's a 6-3 decision again, and this one was written by Justice Gorsuch. They view the prayer or call the prayer personal and quiet, is how they are describing the prayer practice. And I think he explicitly says at one point that it didn't include, the contested exercise doesn't involve leading prayers or with the team or before any other captive audience. So Gorsuch takes a view of just not reality. And you're seeing that's not just FFRF saying this. I think legal scholars, like all of the law professors who deal with religion and anybody who's observed this case kind of see this distortion of we can't even agree on the fundamentals of this case. And we see that in the dissent. This was a Sotomayor dissent, and she includes photographs in the dissent because it blows a hole in the idea that this coach was praying quietly by himself. It was a team activity. It's what he was doing. But Supreme Court disagrees. They say this violates his free exercise rights because he was only being restricted because he was doing religious activity. And then they also say it violates free speech, which is interesting because they say, well, if another coach at that time could be doing something else, like making a phone call or doing something like that, it's not right for the school district to tell the coach that he can't do a prayer on the 50-yard line of the football field immediately after the game. So that's my version of what the majority had to say about it.
And it really is building upon this majority opinion that's built upon like facts that are just outright lies. I think one of the biggest concerns that I have is just how much this court is gaslighting us. And I so appreciated Justice Sonia Sotomayor putting in those pictures in her dissent. I don't remember a time where we've actually had exhibits put into a decision or into a dissenting opinion. But just to show how wrong the majority is.
Receipts.
Right.
This is not a he said, she said. It's like there are receipts. There is a reality here. And the way it works, it's just so infuriating. I'm going to do some catharsis here because to read this opinion as you're going through Justice Gorsuch's words, and he's like doing what Patrick just did, except in La La Land, which is going through the background of the case, and here's what happened, and Coach Kennedy did this, meekly did this, and then the district did that, and it's this mythology. Like, it is not true. And what do we mean when we say it's not true? Well, the way these cases go, they start in a trial court, and everybody files papers saying, this is what happened from my side, and this is what happened from my side, and documents support that, like letters back and forth between the district and the coach and the coach's attorneys. And there's a record of what happened, and it's more or less agreed upon because these cases happen not in a trial where, where the facts are disputed. These are called summary judgment cases, which means everyone agrees upon the facts in the trial court for the most part. There's no real dispute. Whatever happened, happened, and we're asking the court to decide, is X, Y, and Z constitutional, what the school district did or whatever. And that was static until briefing before the Supreme Court, when the coach and his attorneys got the harebrained idea to just change the facts. Let's write our brief and just say his prayer was private, and let's just call it private and personal, and it was quiet, and students didn't, and this mythology of all of a sudden I looked up and there were students around me, and the media took notice. Well, the guy called the media right. And dragged, he did everything he could to get public attention and student participation onto and into his prayers, and his attorneys had the bright idea, and it worked to, at the briefing stage before the Supreme Court, just lie about what the facts were. And the Supreme Court said, that's okay. We will give you positive reinforcement for that behavior by adopting your version of the facts as what undergirds this opinion. And it's just... Pat?
I was just saying, you're not underselling it because why people think we're, have our view, but there was and I believe it's a George W. Bush appointee on the Court of Appeals, so on the Ninth Circuit, wrote in the underlying opinion that ultimately went to the Supreme Court, said that his lawyers spun a deceitful narrative. And I have never seen that before from a Court of Appeals judge, outright calling out an attorney saying what you said is not true. And you would think that this is a judge that might be inclined to somewhat agree with the religious liberty claims. So I don't think you're underselling it at all. And that is extremely frustrating, just as a person committed to the truth of, if you're going to rule against our side, don't make up what's happening here. We know what happened here.
And there's pictures to prove it.
Right. Because, of course, as I just mentioned, Coach Kennedy actively sought out and invited media attention. So there are pictures on pictures and video and, media spots covering what he was doing. And it's obvious, anyone can plainly see he's praying with his players. And it's a circus, people, he's advertising in the media the persecution that he's undergoing, but also like he's readily doing what he wants to do. And it created all this just chaos at these football games because people are rushing the field and, everyone's gathering on the 50-yard line. And so in addition to this school district trying to abide by its Establishment Clause obligations, they're also trying to prevent their football games from becoming a total circus and a hazard, basically. Mm-hmm. And there's pictures and video of all of this. So it's not just, I guess we have to decide who's more credible and whose version of events to believe. So, but that is the version of events adopted by this opinion. And the opinion basically takes it as a given that this was a private, personal prayer that didn't involve students. It didn't encourage or invite student participation. And as such, we hold that, the school asking him to stop that violated his religious freedom rights and his free speech rights as a government employee, which is a departure from precedent in both of those areas in a again, an accelerated way.
Mm-hmm. Yeah. And I would like, Patrick, if you could, to talk a little bit about our amicus brief, because we did focus on what I think was really lost here in this case, and that's the right of the students to be free from religious indoctrination at the hands of the public school employees. And we submitted a brief to the U.S. Supreme Court with a lot of our secular partners in this space. And do you want to talk a little bit about what those arguments were?
Yeah, well, that was we presented two arguments. The first being, this isn't really a case anymore because, a case for controversy, because Kennedy has moved from Bremerton, Washington. He'd moved 2,800 miles away to Florida. So we didn't think he could still argue against a policy in Bremerton, Washington, now that he was long gone, sold his house, bought a new house. But the court didn't care about that either. This kind of goes on Liz's thing, Liz's prior point about the court just taking the cases it wants rather than cases that probably should be addressed. But the second point is really important, and I think that is that similar language was in the dissent, which kind of talks about students, pressure on students. What's the impact on non-religious students? What's the impact on non-Christian minority students? They feel like outsiders. They feel like they're not a part of the team if they've got to go sit by themselves, or they can't, or they want to, curry favor with the coach. They're going to try to, participate in the prayers because coaches have make a lot of discretionary decisions. They tell you what to do. They tell you what position to play or who's on, varsity, who's not, who gets a recommendation. Every aspect of it, it's not like it's, a test that you could objectively check off, but these coaches have a lot of power and authority besides just the social dynamics. So we presented that to the court, and I think, bizarrely, even Justice Kavanaugh picks up on this, because during the oral argument, now he didn't write a separate opinion here, or at least he didn't dissent. He joined the majority, but he asked about that aspect, is, hey, don't players want to, please their coach? And there's really no way to tell if they're, there's really no way to tell if the coach is giving favoritism or kind of punishment on students who aren't participating in prayers. So as much as I think Kavanaugh is wrong on many, many things, it seems that there are some justices who are going through the same mental version that we would about why this is wrong. It's just they think that this was the personal and private endeavor, in which case, if that's the case, I'm not so sure that Kennedy can do what he was doing before, which was a team event. I think the district still could stop him from doing it. But that's what we tried to impart on the court. It became, it was built into the dissent, but it's a problem, for going forward. Students are probably going to face problems because of this decision.
Yeah. So I've spent a lot of time ranting about how the court lays out the facts, and Patrick gave an overview of like what that majority opinion actually does here, but we need to dive a little bit deeper into like, what does this mean for the Establishment Clause? Like, what did they actually do? And it's profound in terms of how much it departs from just decades of strong Supreme Court precedent for complete separation between church and state in the public school space. And for the reasons that our amicus brief argues, courts have been really strong and really uniform in drawing these lines in public schools because of how coercive the environment is, how young and impressionable school children are, and how much the social and the power dynamics are different than any other place in public life, and how the government power is so strong in the public school context. So what does Bremerton do to all of that case law?
I think that's a good question, and I think that's something that all of the attorneys for Bremerton and then for us here are trying to figure out,
right,
where we have the majority of the cases that FFRF handles is religion in the public schools. And so really going through the opinion and figuring out what are the parameters. We know that, they can't directly coerce a student to pray or to join a prayer circle. And we know that they can't do it presumably in the classroom. The question remains whether, if there's like time between the bells and there's no kids in the classroom yet, but they're coming into the classroom and the teacher wants to pray, like those types of things, like those sort of non-instructional but still part of the school day, is that a time where they can engage in this personal private prayer? These are questions that remain to be seen, and I think we're just going to find that there's more litigation about this, but really public schools, I think, are in a really difficult position now because what the court did is really sort of gutted the Establishment Clause and took it away as a defense. I don't know if Patrick has anything to add or...
Yeah, I think just so everybody, all of our viewers know, this is something, and I don't recall the total number of pages, but it might be approaching 200 pages, this decision with the dissents, that it's going to take some review and analysis, because one of the things that the court I think the disservice the court does here is take away guidance that schools already had. They kind of want to throw away this test, this lemon test that applies to many scenarios, and instead say, well, they don't really say that they're overruling their other school cases about school prayer, but they kind of leave things open. So I think school districts might get sued from our side, from the other side. I think the court is going to bring a lot of discord against religious minorities, too, by the way. This isn't really a victory for religious freedom. If you're a Jewish student, you might now be, coerced to participate in religious activity that's Christian. That's not good. That's not something that I think is supportive of the free exercise of religion. So there is going to be stuff that plays out, but as I would read it, I think that those prior cases about prayer at school graduations and prayer at school athletic events as like a broadcast prayer, that those are still good law, and schools can't now just broadcast prayers. It's more a matter of how are teachers and coaches going to try to push this, and what kind of games are they going to play?
Right. And again, in dissent, Justice Sotomayor gave some really good but sad quotes about the impact here. Here's a quote from her dissent, which was joined by both of the other liberal justices. Official-led prayer strikes at the core of our constitutional protections for the religious liberty of students and their parents, as embodied in both the Establishment Clause and the Free Exercise Clause. Here's another quote from her. Yeah, and this is what we were saying before. The court now charts a different path, yet again paying almost exclusive attention to the Free Exercise Clause's protection for individual religious exercise while giving short shrift to the Establishment Clause's prohibition on state establishment of religion. Again, we're seeing that dynamic where the Establishment Clause is just an afterthought and not a concern for this court in protecting and upholding. And like Justice Sotomayor says here again, the fallout is for students. This decision does a disservice to schools and the young citizens they serve, as well as to our nation's longstanding commitment to the separation of church and state. And that's really the bottom line. It's this court continuing, but like across all these other areas, just lurching in an accelerated fashion in its preferred direction, which is the Establishment Clause just doesn't matter as much as the Free Exercise Clause, especially when we're talking about the court's preferred religious actors, which is conservative Christians. And that's just the truth. I am looking to see if we have any questions for today's, oh no, what did I do? Give me a second here. Yeah. All right. We have a question here. Oh, these are questions on Roe. Should we take them?
I mean, we can talk about it a little bit. We are going to be having an entire episode devoted to the Dobbs decision, which overturned Roe v. Wade that came down last Friday. And one of the attorneys will be on that show as well. But,
right.
You know.
I will just say, like, we like everyone else, are just reeling from the past week of decisions from this court. I mean, what we're all feeling from the overturning of Roe and what happened in Dobbs is literally what we're feeling in these religion cases too. It has just been an absolutely exhausting, head-turning whiplash of a week, and we are processing all of this, but don't want it to get lost that, you know, while we were all grieving for our bodily autonomy, the court also eviscerated the Establishment Clause,
right.
You know, like opened up taxpayer money for religious schools. I mean, it's doing so much that we want to make sure we're staying focused on some of these state church separation cases and drawing people's attention to them as we process all of this other stuff.
And really, Tuesday, because Monday was a holiday, Juneteenth holiday, observed by the federal government. So really, Tuesday through Friday of last week, we saw the Carson decision come down. Then we also saw a case that gutted Miranda rights. Then we saw a case that invalidated gun safety laws out of the state of New York. And then we got the Dobbs decision.
Right.
We had 2 days of a break and then woke up on Monday morning to the Kennedy versus Bremerton decision. So this has been rapid fire that we've been taking. And like I said at the outset of the show, our attorneys have been scrambling so much to read these decisions, understand what their impact is on all sorts of issues and what it means for state-church separation, what it means for religious liberty overall. And it's been a lot. All at the same time, they're also grieving because we are upset that constitutional rights have been taken away at a rapid rate. So really, again, just kudos to you guys for like getting up and coming back and fighting for us, because now more than ever, we really do need you.
Right.
And I have a question for both of you, Liz, before if you've gotten any others, because we've all been practicing for, law, and our attorneys, want the system to work and want judges to be impartial. You've both been practicing for quite a long time, and I just curious, like, how does this impact your view of the justice system in general and just how judges make their determinations? Because it seems to me like I'm kind of shaken, and I don't want to be. We want to be on the side of having rule of law, having decisions that we agree with. But I just, want to get your take on that.
Yeah. I mean, in a way, it's been like we've said a lot of times today, it's been this crazy acceleration and all these terrible forces, but that doesn't mean that it hasn't been kind of coming, and we haven't felt this at a slower pace for years. And as this majority has built up, it's kind of like fireproof 6-3 numbers. And so, like, I've been a cynic for years about the promise of justice from our court system, and part of that is being a trial attorney before this, and you
Public defender, yep.
yeah, you know, just kind of the on the ground reality of seeking justice through the courts is that, you know, it's complicated and it doesn't always, or it doesn't even often end up feeling good. But I will say that the pace of just this term and what's happened over the last year, I mean, I think we're commiserating with the rest of the nation, which is, it just feels wrong and unfair. And like, if you're feeling that way, it's not just you, because it is true that this court is, you know, cherry picking cases that don't need to be decided. It's doing activist work, ironically. Like, it's picking these cases, it's, you know, bringing them up, elevating them to the Supreme Court level, and then taking decades of law that we've all relied on, which includes individual rights, and just throwing them out the window, lighting them on fire, and just changing the world we live in so quickly in ways that are harmful and that we don't want. And it's, you know, these 6 judges have that power, and we feel helpless. And as lawyers, we feel powerless because, you know, the tool that we know is just so corrupted.
And I feel like I've always been the person who never liked this term judicial activism, because I thought, you know, when I started practicing 15 years ago, you know, it really was just sort of a euphemism for, you just really didn't like the outcome, you know, but like, I revere the system. You know, we all train at the same schools, take the same bar exam, and we all understand, especially on the federal level, what the rules of civil procedure are, and you know, what to expect. And now we're in a situation where all of the rules have changed too, like the standing stuff that you mentioned earlier, like everything that you learned in law school, we're not abiding by any of that now. And even like, we're just going to make up our facts and do it at the stages we're not supposed to. And we're just going to adopt our own reality and then come up with the law that we want. And Kennedy is like the embodiment of this gaslighting. And I really have always thought like, oh, judicial activism, I don't believe that that's what's actually happening. But now I do. This particular court, these 6 ultra-conservative justices on the Supreme Court are the most activist judges we've probably ever seen. I mean, certainly in my lifetime. But it's so disheartening to have gone through and been trained in this profession and then just see it also just fall apart. And not know really how to help people because the rules of the game have changed.
Right. And a big part of that is the nerd version is stare decisis, but all it really means is it's supposed to be that we don't move at this breakneck pace. Changes in our law, like when the makeup of the Supreme Court changes, you know, it's supposed to be that judges are really bound by prior decisions of the court, even when they didn't sit on the court, and even if they don't personally agree with the outcome. And this court really has been willing, and everyone has experienced this with Roe versus Wade, but it's happening in all of these other cases as well. And just as, you know, like, it accelerated and just as out of nowhere, these overturning of precedents or just completely discarding of decades of precedents of the court that we've come to rely on, build our litigation and strategies around. And of course, like Patrick was saying, school districts are, you know, guidance for the people acting in the world trying to abide by their constitutional obligations, like school districts and other local governments like the state of Maine, that are, you know, trying to do right by their citizens. And and relying on the guidance of decades of Supreme Court precedent, and this court just has no regard for it. So I don't feel good, Patrick. That's the answer to your question. It's hard. I mean, it's hard.
Yeah.
All right, I'm going to ask one of these. Dan Barker is, of course, out there trolling us, saying, isn't the original source of disinformation the Bible? But I'm not going to let Dan get us off talking about the Bible. Yeah, so I'm actually going to save these Dobbs questions for next week, and I promise if you have questions about what happened in Dobbs and all the state church angles and all the catharsis, it's coming next week. So I'll save these questions and we'll answer them and more then.
Yeah. So that's it then for this week's Ask an Atheist. Thank you, Patrick, for Skyping in.
Yes, but before we go, I have to point out that our very own Rebecca Markert, she loves this, was a guest on C-SPAN's Washington Journal just this morning, very, very early. She did an awesome job. You can see the show in its entirety at ffrf.us.cspan.
/C-SPAN.
Oh, did I say dash?
Yeah.
Slash. Yeah, don't come at me with the slash dash thing. ffrf.us/C-SPAN. Rebecca wants you to watch it.
This week on Free Thought Radio, don't miss Dan and Annie Laurie Gaylor. They'll be speaking to author and Supreme Court expert Linda Greenhouse about the recent rulings. Go to ffrf.org/radio to learn where to listen or find it on your favorite podcast app. If you want more information about the Freedom from Religion Foundation, please check out our website at ffrf.org.
Again, tune in same time next week. We will be discussing Dobbs v. Jackson Women's Health, the other seismic case that came down. Thanks so much for watching FFRF's Ask an Atheist.